Hello, everyone, and welcome to my podcast, Human Rights, How Do They Stack Up?, where we explore different aspects of the legal system and whether they uphold or undermine human rights. With every episode, there will be a survey attached in the description, so you can feedback whether you liked it, whether there's anything you would suggest to improve, so please do fill that in once you've listened to the episode, and enjoy! Okay, so hello everyone. Today on the podcast we have Will Marsden from NCH. So Will, thank you for being here. Firstly, it'd be great if you could introduce yourself. What's your role in the law? How did you come to be involved in it?
Thanks, Nicola. It's great to be here. So my name is Will Marsden. I am a third-year law student at the College of the Humanities, and I work with various charities or in voluntary capacities, both with urban lawyers, where I head up the mentoring arm of the charity, and also with Bridging the Bar, where I run the mini pupillage scheme. And I hope one day to practice at the criminal bar and to be a member of the Independent Bar of England and Wales.
Okay, brilliant. So today I want to first look at the UK's court structure, how our legal system works. I think it is quite a clear system in both a civil and criminal sense. Could you explain how cases progress through the criminal side of the legal system?
To start with, you'll have a first appearance, and usually that'll be in a magistrate's court. And then from there, whether or not the offence is serious enough, and the benchmark really is whether the offence carries a tariff of 6 months or more, then the case will go to a Crown Court or it will stay in the magistrate's court. And from there, if necessary, after a trial, if there is an appeals process, then you might have the Court of Appeal, the criminal division, being involved in the case, and in extremely rare cases, at least in a criminal context, you may also have the Supreme Court involved as well. I would say that the vast majority of cases aren't appealed, and so the last you would hear of them would usually be in the Crown Court.
Okay. And so the majority of criminal cases go through the magistrate's court, I think about 95%. How would you describe the role of the magistrates?
So the magistrates themselves have a really critical role to play in the justice system. They're kind of acting as this filtration mechanism. You have to bear in mind that magistrates are not necessarily lawyers by training or by vocation. And so their role is really to dispense justice as they see fit. And one of the ways the magistrates court, the architecture of it is set up, is that there are 3 magistrates on the bench at any one time. And so you can never have a deadlock. And so it's thought that having at least 3 voices, 3 opinions means that the right decision will be come to. The reality that I've seen is perhaps a little different from that. Many magistrates don't quite have what I would consider the requisite legal knowledge to really be making decisions about an individual's liberty.
So I'm guessing you don't consider a training period of, I think it's 3.5 days to be satisfactory?
I don't, not at all. And you're quite right, it is 3.5 days. The exams and the tests that you need to pass are not exactly rigorous. And, ultimately you can be in charge of somebody's future trajectory. Prison doesn't just end after the 6-month tariff. Unfortunately, it carries ramifications in society that can really change the course of a person's existence forever. So I really think there ought to be more training and actually more thought into how the magistrates' court system is set up, because it currently relies upon, albeit their expenses are paid, but volunteer magistrates. And so that in itself attracts a specific demographic of people, those who are wealthy, not necessarily just in terms of money, but also in terms of time. If you can afford to volunteer a couple of days a week to go and do something in a voluntary capacity, the chances are you're not struggling to put food on the table in your family's home.
And I guess that I don't know any statistics surrounding this, but does this lead to a lack of representation?
So then the magistrates, I think the lay magistracy is made up predominantly of privileged white women of the age of about 60 plus. And I'm afraid that is, that is a product of the way the system works right now. If we had a paid magistracy, if we had proper training and it was a career, it wasn't just a voluntary undertaking, then you might see some differences in the results. But in its current form, the system, in my submission, is not fit for purpose if we believe that the justice system relies upon a fair representation of the society in which it operates.
And I guess within that system, do you think there is a potential for miscarriage of rights then? Because you have limited expertise, lack of representation, do you think there is definitely that potential for such violations, perhaps?
So I think it's important to note that the potential is there in any system to an extent. There is a potential. Does that potential increase? Does the likelihood of those miscarriages of rights or miscarriages of justice increase because of the way the system is currently set up? Yes, I think so. And I could see that systemic changes to the lay magistracy in particular would likely yield fewer of those miscarriages of rights and miscarriages of justice. But it's important, I think, to say all of this with the caveat that no system is perfect and every system and every court makes a mistake.
Absolutely. So moving up now to the UK Supreme Court, could you explain its differences with the US Supreme Court, which I think people are generally more aware of?
Yes, and I think the first thing to say is that there's a reason why people are more aware of the US Supreme Court, and that is because the process for appointing justices is very political and is it draws a huge amount of media attention, public opinion, public engagement. Most people in the United States would know the names of the justices on the Supreme Court. The same is certainly not true here. Now, on that appointments process, the first thing to say is that in the UK, or in England and Wales, as our jurisdiction is called legally speaking, we have what is called a mandatory retirement age of 70. And so all justices have to retire at 70, recently down from 75, regardless of the soundness of their mind, how long they've served at the bench. If someone went to the bench at 67, they'd have 3 years, for example. The United States, as we saw recently from the death of Justice Ginsburg, there is no mandatory retirement age. And so you could have justices hanging on literally for dear life into their late 80s, into their early 90s, with no real regard for how sound their mind is, how sound their body is. And the problem is, in the United States also, is that the system is inherently politicized, and in the appointments process, which is undertaken by the president, the sitting president, you have either Republican or you have Democratic nominees. And it is expected that once those nominees go on to the court, that they'll make certain decisions on certain big issues of the day. And those might be abortion, those might be the death penalty, or any other issues that arise. In the United Kingdom, we have a much more streamlined process of appointment. There are certain criteria that you have to fulfill to qualify as a potential applicant. And from there, the Judicial Appointments Committee, which is a separate body, is independent of any political party, makes the appointments itself. So those are the sort of main differences as to the appointment of justices.
Okay. And the entirety of the court system is based on common law. And for those who aren't aware, could you define that term?
So the common law, broadly speaking, is judge-made law. Judge-made law is that which is made by judges in courts, and that follows a Latin phrase, stare decisis, or let the decision stand. And this is really the plank that underpins our justice system, and it's the emphasis and basis on precedent. So if you set a decision, let's say, on wooden tables in the United Kingdom Supreme Court, then all the courts below that, so the High Court, the Courts of Appeal, the Crown Courts, the County Courts, have to abide by that decision. The only court that can overturn a decision of the Supreme Court is the Supreme Court itself. And so common law really is that law that is made by judges, that is not made by Parliament.
And what advantages do you think there are of this approach that we have?
There's a famous phrase by the late, great Justice Bingham, who said that precedent is a guide, but not a cage. And I think that really sums up the essence of why precedent is so good. It allows and affords both a flexibility, but also a set of rules for which courts to abide by. You know, without rules, we enter chaos, we enter anarchy. At the same time, precedent allows the court to respond to issues of the day, to public opinion, and to what justice means on the facts of that case, that a rigid statutory based only system would never allow.
Do you think that there may be risks involved in that, perhaps, such as, let's say, the perpetuation of bad decisions, or just bad decisions or wrong decisions for the current climate, perhaps?
Sure, I think so. But I think that the current system and the system of precedent allows you to respond most agilely, most flexibly to what is going on or what the mood of the day is. And I think, yeah, it's true. Once a bad seed is sown, it is hard to get it out of the system. But the beauty of the courts is that once the courts make a decision, that becomes law instantly. Parliament often takes a lot longer. There are a lot more people involved. And so I would suggest that, yes, of course, the perpetuation of bad decisions is possible. However, it's also quicker and easier to overturn those bad decisions, if that makes sense.
Yeah. So do you think it's almost, precedent allows for almost an evolution of the law in a quicker fashion, though, obviously?
Absolutely.
So moving on to the International Criminal Court, so looking more at a macro level, it's one of those multilateral bodies that attempt to enforce international law. How would you describe its role within the global legal system?
So the ICC is the International Criminal Court, as you rightly say, and so it is a court that sits over and sort of supervises the international criminal law. So that's not the law of tort, that's not employment law, it's specifically criminal. And I think that's important to signpost from the outset. Now, in terms of what its role is, its role is really primarily confined to prosecuting those who are responsible for the international crimes of genocide, of crimes against humanity, and of war crimes. So really the worst of the worst. You know, crimes against humanity might be the systematic murder of hundreds of people. War crimes could be, you know, all sorts of really awful abuses against women and children. And so it's the International Criminal Court's role to enforce the law on those issues and to hold individuals to account. And I say individuals because really the ICC doesn't hold countries to account, and it really hasn't in its 18 years that it's been going, has never once taken on a state or a nation at all. Its remit has really been confined to taking on and seeking justice against specific individuals for their individual action.
And In what ways does it have jurisdiction? How exactly does its jurisdiction work in certain countries?
So again, it's based in The Hague in the Netherlands, and really its jurisdiction is somewhat of a mess, to be totally honest, because there are certain countries that have been quite outspoken in their disagreement with the ICC. An example of that might be the United States, which, for example, Barack Obama basically outright told the ICC that it was not doing anything properly, and that its basis treaty, which is the Rome Statute, was basically defunct and null and void. Now, there's also been various controversies that the court is unduly, biased towards taking action against certain states, and also perhaps willing to overlook the actions of others. And so really, there's not an easy answer to your question in terms of its jurisdiction, other than that its role, its remit, is to uphold the Rome Statute, which declared various actions a crime against humanity or a war crime. And those might be things like enforced sterilization or apartheid or the sudden disappearance of people in the middle of the night, systematic torture, enslavement, genocide. The list, rather gory one, goes on.
Do you think the International Criminal Court should have complete jurisdiction in the complete sense of the word international?
So I think, it can only have jurisdiction if every country in the world signed up to it in the first place, if every country funded it. The problem you have with these international multilateral bodies is that someone has to fund them, and not everyone is going to fund them equally. And so you have conflicts of interest, no matter how independent you can say the justice or the prosecutor might be in the ICC. The reality of the fact is that certain people are paying their wages. And if those certain interests, committed crimes, it would be interesting to see if the ICC really went after them in the way that they would against, someone from a country that doesn't contribute as much. So, for example, they took on the Libyan revolutionary Muammar Gaddafi. They took on the man Joseph Kony, who was behind that whole Kony 2012 Ugandan rebel sort of craze, I suppose. And so, yeah, I think it's difficult really to ever get to a point where it's completely and truly multilateral in the truest sense of that word.
Do you think, however, it could be improved if, I think most notably, like you mentioned, US isn't involved, China isn't involved, and I don't think Russia is either. Do you think it would have more credibility if these countries did choose to join the Rome Statute?
So I think possibly. However, I just don't know how likely of a reality that is, I suppose.
Mm-hmm. And I guess considering that the ICC is based on the Rome Statute, so it only has jurisdiction if a country chooses to sign up, do you think that does fundamentally hinder its abilities to enforce international criminal law?
I think so, absolutely. And you have to remember that international criminal law is only that which is decided by the Rome Statute. So you're kind of in this cycle where I declare, if I declare it to be international criminal law that tables cannot be brown, and France says actually, well, they can be. France hasn't agreed to that being the law in the first place. And one of the sort of tenets of the rule of law in general is that the law is agreed upon and accessible by all. And that's sort of undermined, I suppose.
And considering how the ICC is based, how it functions, do you think that this could allow the perpetuation of human rights violations? So in China, you have the genocide of Muslims, and do you think that if the ICC was structured in a different way, that perhaps less human rights violations would be carried out?
So I think we should be careful with the Uyghur Muslim issue. Whilst there has been some news coverage of it, there hasn't been, at least I haven't seen any evidence to suggest, or there's been evidence to suggest, but there's not been clear-cut evidence to show that there is a genocide taking place. I think we should be careful with the terminology, because I think without attention to that detail, then we get lost. What I would say is that, you know, as I mentioned earlier, the ICC has traditionally taken on individuals, and it's been quite controversial in its taking on of those individuals, and has really not had a huge amount of success. You know, it's been going for over 18 years. I think it's in its 19th year now. It started in 2002, and has prosecuted about 40 people. It's not a great rate of prosecutions per year. And for it to take on the biggest country in the world in terms of population, in terms of military might, arguably in terms of GDP soon, I see it as highly unlikely. I think it would be unfair of us to see the ICC as a panacea to solve what may well be going on in China. I think that needs fundamental international cooperation from more established and more powerful bodies such as the UN Security Council and others, who need to actually go in and investigate. The problem is, of course, you get into the issue of, well, what is the remit of the investigation? I mean, we've seen with the COVID, it is likely that COVID started in China. Now, the access or the lack thereof that the World Health Organization's investigators have been given to those places in Wuhan province is questionable. And so it's very difficult really to know how you solve this without a full-on war, unfortunately.
Thank you for the clarification. I should have researched more into that, so thank you very much for that. And you just spoke of the pandemic, which I guess moves us on nicely into the next section. And there's no denying that the pandemic has had a startling effect on the criminal justice system. How has the system had to adapt in the way that it handles cases?
I'd say the first thing is that just the lack of court appearances has been a real issue. And the way in which the state can detain and imprison people pre-trial is also an issue. And so if we deal with the first of those, the lack of court appearances has meant that many easy hearings, small hearings that you don't actually need to travel and shouldn't need to travel for, have gone on to line. It's called the PCR, and it's like a video link, and it's worked fairly well. I think the criminal bar in general has been very supportive of this change. You know, before you would, as a junior criminal barrister, you'd run from Maidstone Crown Court to Snaresbrook Magistrates Court to Isleworth to the Central Criminal Court maybe in a day. And that's really difficult in terms of travel time, in terms of managing your diary. And so to be able to do it from the comfort of your kitchen, I think is been great. Does that raise issues of the rights to a fair trial? Of course it does. And I think that because, as you rightly say, the system has been forced to adapt under these circumstances, I think there is still a lot of work to be done to ensure that, you know, privacy concerns are met properly, that the actual technology is there, the infrastructure is there to perform these. I think overall, though, it could be seen as a good thing, as sort of accelerating as the catalyst to pushing a very outdated and archaic criminal justice system towards the future and in line with the technology that we see in our everyday lives. Now, as to the second point, in terms of indefinite detention, this is a real issue because it is fundamentally against the European Convention on Human Rights to indefinitely detain somebody and to do so for a period that is not specified. The issue is, of course, is that it's so hard to get a jury trial up and running in COVID with 12 people drawn from different homes. That's like a super spreader event waiting to happen. And so it's been very hard to perform those jury trials. Obviously, crimes have still been committed that need jury trials. And so trials are being kicked further and further down the road, meaning that if it's a serious enough crime and the accused has been refused bail, then they could have been in prison this whole time. Not only in prison, but in prison without access to any family member visits and in their cells 23 hours a day, 7 days a week, because of the risk of spreading COVID in prison. And so it's not a good time to commit a crime. It's not a good time to be in prison if there ever were one.
And I guess, can you see there being potentially a review post-pandemic, but when things have gotten better, that there is some sort of review into how that system operates?
I think, the calls have been ongoing for, over 2 decades now for reform of the criminal justice system. And I think the one good thing about COVID is that it's really brought home into stark relief just how desperate the system is for some modernization, for some money, to be totally honest. The Crown courts I visited have leaking toilets, they have ceilings that are falling in, they have broken lifts, which is a problem when you have 3 judges who are not able to climb stairs. And so I think, I hope that there is a review. I don't have a huge amount of faith that the current government is going to do much about it, but I do hope that people realize that, justice is one of those things that people don't take seriously until it touches their lives. But I think the best analogy I could draw is, we take for granted our NHS, and perhaps the pandemic has stopped us doing so a little bit, and people have started appreciating just how important this national, right really is. The same should be true of other public services. The justice system is one of those public services, and justice on the justice system will only touch you, and will touch you when you least expect it. I think we all would do well to make ourselves aware of the issues faced by the system and work towards solutions.
Absolutely. And I guess one of the things that I noted about the pandemic was how it highlighted this lack of data handling. Like you said, the criminal justice system is lacking in modernization, and that does result in kind of data gaps and information gaps. I think one example was the backlog data specific to youth courts is not produced. And with this extended period of the pandemic, you have youths moving into adult courts as well now. How do you think the justice system should go about tackling this issue of lacking data collection?
So I have not a huge idea as to how it could do this better. I think that's probably a job for data scientists or for people who are experts in the area. I think clearly, just from a really cursory sort of off the cuff view, I think it's very obvious that youth data under the age of 18 needs to be processed differently to that of adults, and how you give consent, even just at school on like parental consent form, differs depending upon your age. And so I would assume that it would have to go down those same lines. But the handling of it and the mechanics of that, I'm afraid I'm not well placed to be an expert on.
Don't worry about it. It's a difficult question, I get it. And I guess as a final question, taking everything we've spoken about into account, do you think there are some sort of, I guess, loopholes or cracks within the justice system that allow almost miscarriages of human rights, human rights violations to fall through unnoticed, or to just kind of linger in the background?
So I think absolutely there are cracks and loopholes in the system. That's the first thing to say. Undoubtedly there are. And I think the one I mentioned earlier on indefinite detention is a good one, because we don't have a system that responds in a flexible, agile way to crises. And I think right now, it is an enormous miscarriage of justice. It is a violation of one's rights to be taken away from your home, to be put in prison, to be detained for something that hasn't even been proven against you yet, right? So you could be on the current rules, and what happens, to give you a bit of idea of the detail, is that the prosecution will apply for a custody time extension. And the judges often will grant that because we are in an emergency situation. People make jokes all the time about when does an unprecedented time become precedented. I don't think anyone has an answer to that. The law doesn't have an answer to that. And what that means is that emergency laws passed for emergency circumstances are being used a year on from the beginning of that emergency. And the result is that many people who are actually probably innocent, there will be innocent people caught in this rough, blunt instruments sort of remit, and that's not right. And so I think if there is a review, there needs to be one into how you define an emergency, how you then apply emergency powers to that emergency, and when that emergency expires and those powers expire too. Because otherwise you get into very dangerous territory of just locking people up because you want to, and there being no real evidence against them, there being no opportunity for them to prove their innocence. And that is not a state or a country that I would be proud to be part of.
Correct me if I'm wrong, but I believe that for some of the emergency laws for the pandemic, they were almost processed overnight. So there wasn't really that kind of extended process of thoroughly looking through, examining, and then creating that almost expiration date for these laws.
That's correct. And so all of these laws have been passed under a public health emergency set of laws from the 70s. And you're quite right. The need for parliamentary oversight, the need for the normal voting process is curtailed under those laws. I mean, the result has been a lot of bad law. We've seen it at every turn, the rule of six, or the rules outside, or, it's very hard to keep track of what is law and what is guidance. And I think I counted that there were 34,000 words of coronavirus related laws that had come out in the last year. I mean, try asking any local police officer if they can recite them. And they're the ones enforcing the things. So it's a pretty dire situation. And I don't pretend that it's easy to make law in a pandemic. I don't believe that it's an easy job, but I perhaps think it could have been done better than it has.
Well, thank you so much, Will. I hope I've really enjoyed this discussion, and I hope everyone else has. Thank you for your time.